Okay, we're going to get started here. Welcome to our webinar. This is Alan Gassman, and I'm here with my friend and colleague Lester Perling to talk about the Florida medical marijuana law. We've had this recent legislation. Governor Scott has indicated that he will sign it. Seaver Brown and I have been working on an article on the new legislation. We've sent all of you a copy of this week's Thursday report, which has a pretty long outline. Seaver did most of the work, and I'm going to take most of the credit. But this law is much more clear than the law that we had before, and it's going to do a lot of good things for a lot of good people, no doubt. Before I introduce Lester, let me go ahead and just mention that we have his biography here. He is a very, very well-qualified, board-certified health lawyer, former CEO of a hospital, has a master's degree, and also is an adjunct professor. So Lester really knows his stuff in this area, and he has been kept posted on this marijuana law as it is developed as a very political and interesting phenomenon. You've got my biography there that does you no good whatsoever. Then the invitation, please join us Thursday, June 29th, 12:30 p.m. Lester's going to lead a discussion on the recent law changes for both Florida CMS and Accountable Care Act. We're going to have a lot to talk about on June 29th. Please do join us. For those of you in the tax world, you know Ed Morrow, you know Joy Spence, you know Jerry Hesh, you know Christy Nicolo. Please consider joining our Bloomberg webinar series. We have a lot of these. If you're in the St. Petersburg area, Monday, August 21st, Marty Shinkman and I are going to be talking on asset protection and planning for chronic illness over at All Children's Hospital. It's going to be a really good program. Anywhere Marty goes, you know you're going to have a great time. Then on Tuesday, August 17, Jerry Hesh and I are going to be in Sarasota. Please come see us. We're going to talk about asset protection. Jerry's going to talk about charitable planning techniques. It's sponsored by the Jewish Federation down in Sarasota. Lester, I'm going to turn this over to you, and I'm delighted to turn your pages, carry your books, and anything else I can ever do for you.
Well, thank you, Alan. My shoes are a bit dull, but I'll send them over. So good afternoon, everybody. So after a whole lot of anticipation and effort and more than one try, an amendment to Florida's Constitution was finally passed to do what the legislature wouldn't do, which was expand the use of permitted uses for medical marijuana in Florida. So as you can see, the actual history looks short here because the first statute was actually passed in June of 2014, or became a law then. But you know, there were efforts with regard to constitutional amendments and whatnot before that. I won't go over this whole slide. You can look at that yourself. The important points for today's discussion really is the Amendment 2 having passed on November 8th, and the Senate Bill 8A, which is the new statute, actually passed before June 16th. But the last thing that occurred was on June 19th, which is when it was presented by the legislature to the governor for signing. And as Alan mentioned, the governor says he will sign it, although he has not as of this morning, at least. At the same time, the Senate Bill 8A was passed, Senate Bill 6A was passed, and that actually addresses public records related to the use of medical marijuana, and we'll discuss that a little bit. Then on June 16th, the Department of Health issued its initial proposed regulation implementing Senate Bill 8A, which, although it isn't law yet, had been passed by then, and DOH has already issued a proposed rule. So next slide, Alan.
On its way.
Okay. So this was the original, well, the Compassionate Medical Cannabis Act, which I'm going to actually skip this slide because it's kind of outdated now given the new law. It's in here for your history. The Right to Try Act was the initial law, which, excuse me, the second law, which is also history. We're going to skip that because we have limited time. So let's start with a little bit about Amendment 2. It was approved, as I noted, in the 2016 election. It became effective on January 3rd. And DOH actually, there was a lot of until the legislate, well, actually now until the governor signs the bill and it becomes law, there's been a lot of uncertainty as to whether or not somehow or other physicians could go ahead and implement Amendment 2 and whether or not to some degree it was self-implementing. And the Department of Health kind of created some confusion around that with some things it posted on its website. Fortunately, the legislature did pass this bill that kind of cleared up what was then for a period of now a few months, which was kind of a mess. So what Amendment 2 does is allow the medical use of marijuana for an expanded list of conditions, which we'll go over. It allows caregivers to assist individuals on their use of marijuana. It also provides for additional registration of marijuana treatment centers, as they're now called, I believe. And we'll talk about in the bill, there was a limit to 3 of those, and now that's been expanded. So there will be more what used to be called marijuana dispensaries and now called treatment centers. The amendment required that to be eligible, you have to be a permanent Florida resident. However, seasonal residents can provide the department with proof of residency and still be eligible to get medical marijuana. So snowbirds will be in luck, and then you must be diagnosed with a qualifying physical condition, which we'll get into. Next slide. So here's just some highlights of what the Senate bill does, and we'll be going over some of these things. It adds a lot of definitions, a couple of examples here. As I mentioned, one of them is medical marijuana treatment centers. Instead of calling it medical cannabis, the legislature is calling it what it is, which is marijuana. So they've sort of simplified that, since that's how the public knows it. It doesn't really know what medical cannabis is. It establishes the qualifying medical conditions, which are really in the amendment anyway. Talks more about prescribing requirements and requirements for prescribing. It amends the informed consent requirements, provides some dosage limits, etc. So we'll get into some of these in more detail. Next slide, Alan. So originally, the first bill in Florida allowed the use of low dose or low THC cannabis for a very limited purpose. That was known as Charlotte's Web, named after the individual Charlotte Figi, who used medical marijuana as a child to help her seizures. Next slide, Alan. The subsequent bill expanded the use, so it's no longer limited to low-dose THC for terminal conditions, and that's when it allowed the use of what is now known as marijuana. As I mentioned, the name now has changed from medical cannabis to marijuana, and the definition of it has changed slightly. They're in the slides. I don't need to read them for you. They're pretty similar, but they have been altered a little bit. If that interests you, like I said, they're in the slides. Next slide, Alan. So here's the qualifying medical conditions under the amendment and the statute. I think, as you can see, they're listed fairly specifically up until the bullet point, the third from the bottom, which are medical conditions of the same kind or class or comparable to those enumerated above. So while these conditions were specifically enumerated in the amendment and statute, other similar conditions could be qualifying based on the opinion of the physician, so long as they fit that general sort of category of being the same kind or class or comparable. That's pretty broad, and it'll be interesting to see how that develops. And I'm sure that physicians will, or at least some physicians, will push that envelope. And as we'll talk about near the end, there might be some consequences if they push it too far, in the opinion of regulators. So that's something to watch. A terminal condition which can be diagnosed by any physician, not just somebody that's the qualified physician, which is the physician who's permitted to issue the certification that allows the use of the marijuana. So when a physician orders the use of the medical marijuana, it is not a prescription technically, but a certification that the patient meets the qualifications to use marijuana. And then the final category is chronic non-malignant pain, which is defined in the statute. That's a phrase that some of us are familiar with regard to pain management clinics. It essentially means pain not associated with cancer that has lasted longer than one would expect based on the condition. So, for example, if I have a back problem, I have surgery, and the pain continues past when normally it should have subsided post-surgically, that becomes chronic non-malignant pain. Again, there's some vagueness to that definition, and there could be some room to push the envelope, and again, some room for pushback from enforcement authorities. Next slide, Alan.
So Lester, before we go on, chronic non-malignant pain will be something that it can be prescribed for?
Yes.
Thank you.
All right, so who's a qualified physician who can prescribe or certify more properly marijuana? So it's only physicians licensed under 458 or 459. The definition is fairly clear. I think that it would not include a physician assistant, even though they are licensed under 458 or 459 because they are not physicians. Clearly, nurse practitioners who are not licensed under 458 or 459 are not included. So this is a physician-only statute, which to me seems, given the scope of what nurse practitioners and physician assistants can do in terms of prescribing controlled substances, seems a bit limiting, but nonetheless, that's what it is at the moment. And then there are specific training requirements. We won't go into what they are. Again, you can read them here or in the statute. And there will be an exam. The physician does have to take a course and renew the course. It's not really, I don't believe, a huge hurdle for physicians to jump over if they wish to add this to their practices. I doubt any physician is going to have any problem passing the exam with regard to the laws and rules that govern the prescription of marijuana and whatever else may get covered on this exam. So it's a fairly low hurdle. Note that physicians, though, will not be able to dispense marijuana. Only the marijuana treatment centers that are authorized and licensed by the Department of Health can do so. So even a physician who has a dispensing practitioner license can't dispense it, which isn't too surprising because those physicians cannot dispense any controlled substance, and marijuana is a Schedule I controlled substance under that permit. Note importantly that a qualified physician cannot be employed by or have any form of economic interest either in a marijuana treatment center or a testing laboratory, which are the labs that will be authorized to test the product to make sure it meets the standards that are set for it. So the marijuana treatment centers, despite their name, which I think is a little bit misleading, really won't be treatment centers in the sense that I can't go there and get certified and then get my marijuana. I have to go to my doctor's office, which can't really be affiliated with a treatment center directly anyway, although perhaps it can be co-located with a treatment center, and then go to the treatment center to get my marijuana. So next slide, Alan. So requirements for prescribing. Under the immediately prior law, there was a waiting period. There had to be a doctor-patient relationship for, I think it was 60 days, maybe 90. Before the doctor could actually prescribe the marijuana. So I had to establish a physician-patient relationship, wait 90 days if it was a new doctor, and then get my prescription. That's not included in the new law. So I can go to a doctor who's a qualified doctor. If I meet the requirements, I can go ahead and get certified. I think the first bullet point is important. Telemedicine is not permitted for the prescription, initial prescription. There has to be a physical examination with the physician present in the same room. So the legislature was making it really clear that not only can't you use telemedicine, but the physician probably can't even use a mid-level to conduct the physical exam. It has to be conducted by the qualified physician. The patient, of course, has to have one of the qualifying medical conditions. The physician has to determine that the medical use would outweigh any potential health risks. And if it's a child, there has to be a second physician has to agree that the child has a terminal diagnosis, if that's what it is. Can't be prescribed for a pregnant patient. The physician has to review the controlled prescription drug history of the patient in eForce, which is the Florida Prescription Drug Database, and make sure that there's not already an active certification so that the patient isn't double dipping it, so to speak. Next slide, Alan. So the physician has to register the patient as a user in the registry, which already exists. It has to enter the physician has to enter certain information, update the registry within 7 days. When the physician no longer is recommending the use of marijuana, has to deactivate the registration of the patient. And failure to do all these things can result in discipline against the physician, and has to obtain the voluntary and informed consent of the patient each time there's a certification. So that includes on a recertification. Next slide. So here's the requirements of the informed consent generally. First is that the patient has to be aware that the government considers this to be a Schedule I controlled substance, along with the fact that it's subject to the oversight of FDA. Basically, the use of marijuana for medical purposes or otherwise is still a federal crime. Schedule I is the list of all drugs that have no medical purpose and cannot be lawfully prescribed or even used for research for any reason, and that hasn't changed. So we'll talk about that towards the end a little bit more, but it's an important point for doctors, patients, and those of us who advise them to remember there's at least theoretical risk in doing this. The physician in the informed consent has to cover the current state of research, the potential for addiction, the potential effect it may have on coordination, motor skills, operating a motor vehicle, etc., side effects, risk benefits, and that information will be in the registry and used for research purposes. I think it's important to note that, about driving motor vehicles or operating machinery, marijuana, including medical marijuana, the low dose, the Charlotte's Web, did not provide a high. Medical marijuana does provide a high. So patients who use it and then go out and drive or operate machinery are subject to DUI charges and obviously could potentially get hurt. I think it's really important that when physicians do an informed consent, they don't gloss over this, because if a patient does get hurt and the patient claims, well, my doctor didn't tell me I could get hurt, or I shouldn't drive, or I shouldn't use all the heavy machinery I have at my home or at my workplace, there's going to be potential liability for failure to provide informed consent. Here is, under the next slide, Alan, under the Right to Try Act, which is the new statute versus the Compassionate Use Act, a comparison of the informed consent requirements. We won't go over that. Next slide.
I think it's worth saying that the consent form will be issued by the government, so doctors don't have to customize their informed consent form. So the one that we drafted for the health law section can be thrown away.
So reissuing certification. So before reissuing a certification, the physician has to evaluate the patient at least once every 30 weeks. And then the following bullet points define what has to be done during that reevaluation or recertification period. Note, it doesn't specifically require a physical examination, but keep in mind that there are some rules that govern prescribing controlled substances using telemedicine. So there's a question of whether or not this can be done using telemedicine. I would not try to do it that way. I think it's going to subject the physician to disciplinary action. I think it's a statute, it might be the proposed rule, says that for those patients who already have an active order and are a registered user under the old law, their certifications are still good until the DOH issues new medical marijuana cards. Next slide. So the statute provides some dosage guidelines. None of us are physicians, so these aren't, I don't think, well, maybe we are. They're laid out here. The initial supply can be no more than, the initial certification rather can be for no more than 3 70-day supply limits based on the dosage. And the Department of Health will publish a rule that talks about dosage, and I think that might be contained in the new rule, I don't quite recall, or the new proposed rule. And then a physician can request an exception for the daily dose limit, and here it tells how the physician can request such an exemption and the department's approval process. So next slide. So what has been known up till now as the Compassionate Use Registry will now be known as the Medical Marijuana Use Registry. Department's going to monitor it, obviously, to ensure that or try to ensure as much as possible that there's not unlawful diversion, that individuals are not getting certified by more than one physician and double or triple or quadruple dipping, which would mean more likely than not that they're selling their medical marijuana on the streets. The registry will be accessible to law enforcement agencies, and I'm sure they have been, and I'm sure will be continuing to watch probably even more carefully now that the number of medical marijuana users has increased. We all know, with opioids that patients most often, or sellers, dealers, most, get their opioids initially by physician prescription and run around to different physicians, get multiple prescriptions. Obviously the same can be true for marijuana, so that's clearly going to be monitored, I think, by law enforcement. Next slide. The statute requires the Boards of Medicine and Osteopathy to develop a joint physician review panel that's going to look at the number of prescriptions, the number of physicians, and generally look at the data, and then starting in January of next year, submit an annual report, as it states here in the last bullet point, so that the legislature can sort of track what's going on with this law, obviously potentially for future amendments to the law. Next slide. So potential for discipline. I think the first slide is important because physicians need to really be careful about this. It's a first-degree misdemeanor, which is a prison term of up to 1 year and a fine of $1,000, but the prison term may be more important, as well as the potential disciplinary action if a qualified physician issues a certification without a reasonable belief that the patient is suffering from a qualifying medical condition. And as you recall from the beginning, I hope, the list of qualifying medical conditions isn't totally specific. And it does give latitude to the physician to determine that if the patient either has a chronic non-malignant pain or has a similar condition to those that are specifically listed as qualifying. And so physicians need to be very judicious in their use of those two categories. And they better carefully document what constitutes, what forms their reasonable belief as used by the statute, that the patient falls within a qualifying category, so that if it's ever questioned, and keep in mind the registry is going to get monitored, they're going to be able to support it. Because if they see a physician who is writing for, certifying for questionable medical conditions, I'm sure that's going to get some attention at some point once it comes to the law enforcement or the Board of Medicine or osteopathic medicine's attention. The second bullet point I think is important too. A qualified physician who issues a certification and receives compensation from a treatment center related to the issuance of a certification is subject to disciplinary action against his license or her license. Does that mean the physician can't, let's say, lease or sublease space from a treatment center, which I know has been occurring to some degree with the current, what are called dispensaries? Probably not. It's not related to the issuance of a physician certification, but it needs to be very, if you're going to try it, it needs to be very carefully structured. It needs to be a fixed fair market value lease, and probably be a one-year term, very much arm's length, but understand it could carry some risk. Issuing a physician certification not compliant can lead to disciplinary action. The Department of Health can issue cease and desist orders and seek injunctive relief. So next slide. The statute contains a lot of detail regarding medical marijuana treatment centers, which are not in these slides. They're way too much to talk about. So I recommend you look at the statute for those. It's all pretty straightforward. We put a few things here in the slides. As I mentioned earlier, the number of what are now called dispensaries will be marijuana treatment centers will be increasing significantly. And keep in mind, each of the 10 applicants as is listed here can have multiple locations. So they're not necessarily just 10 locations. They're going to be 10 licenses issued, and those licensees can have more than one location. There's some more requirements in the next slide. Let's skip that one now and go to privacy. So as you probably know, Florida has a very broad public records law, which means that the medical marijuana registry could be subject to public scrutiny, and patient information will be in it and otherwise available to prying eyes. So Senate Bill 6A, as I mentioned at the outset, exempts from the public records law any personal identifying information relating to medical marijuana held by the department. And this covers both patients, caregivers, and physicians. And again, there's more detail in the slides. I don't want to, we're about at time, so I'm not going to go over the detail here. You can look at it in the slides. And it is a crime to violate those exemptions. So moving forward, Alan, to be the next slide, which we are literally doing. Keep going. One more. There we go. We have moved forward. So as a reminder, the bill has not yet been signed into law, although the department has issued a proposed reg. Let's go to the next slide, which actually talks about the proposed reg. So that was published, as I mentioned, on June 16th. Relevant to physicians and patients, it talks about the registry and registration requirements. It requires what's being called a compassionate use registry identification card. Of course, the registry isn't called compassionate use anymore. Just looking, and if you're a caregiver or going to be a caregiver for a medical marijuana patient, which allows you to pick up the marijuana and handle the marijuana, which otherwise you couldn't do, you have to actually be fingerprinted, probably because you're going to be allowed to handle the marijuana. Next slide, Alan. What's still illegal? Smoking is still illegal. That is not in the amendment, although vaping is not illegal. John Morgan of the eminent law firm of Morgan & Morgan has indicated he's likely to file a lawsuit about that because he thinks that because the amendment doesn't limit smoking, that the legislature had no authority to do so. I don't think he's filed it yet, but has said he intends to. You can't use it in any form of public transportation, in any public place, place of employment if restricted by an employer, so it means an employer can allow it, and some other places. If someone's still using the low-THC, the Charlotte's Web cannabis, that can be used in public places because it does not create a high. And keep in mind, as I mentioned earlier, it's still illegal under federal law, and Attorney General Sessions is not a big fan of medical marijuana or those states that have legalized the use of recreational marijuana. He issued a memo on April 5th of this year to all of to the Attorney Generals, the local U.S. Attorney offices. And it's called Update on the Task Force on Crime Reduction and Public Safety, and it covers a number of topics that are kind of his priorities. But one of them talks about, one of the points he mentions in this memo is that their task force subcommittees are going to review existing policies in the area of charging, sentencing, and marijuana to ensure consistency with overall strategy. That's kind of a vague statement, but it a little bit telegraphs that he's not going to be passive when it comes to the use of marijuana, even for medical purposes. There's a bill pending. I'm probably not going to go anywhere, but who knows? There is a bill pending in Congress that would require the Department of Justice to respect states' rights with regard to the use of marijuana, which one would think would be attractive to a Republican Congress president and attorney general, but I'm not sure it's going to be when it comes in the context of marijuana. Next slide, Alan. I think we've covered these issues, but just to recap, there are some issues. There's obviously the requirement of face-to-face evaluations, potential kickback issues, and physician relationships with treatment centers. Obviously, the issue of illegal prescribing, no telemedicine, whether that'll change or not, I very much doubt it. I would be shocked if it did. The role of physician extenders, like we talked about, and you can scratch out when conducting initial consultations since they're going away. What about physicians involved with ancillary business, for example, forming a marketing company on behalf of a treatment center and doing other types of creative financial arrangements with treatment centers? I'd be very, very cautious about those if I were a physician. The recent Miami Herald article said by 2018, which is not far from now, that medical marijuana users will spend nearly $200 million in Florida, and that will be growing very rapidly. And by 2020, Florida will make up 14% of the nation's legal marijuana use, and that includes those states that permit recreational marijuana. So it's going to be big business here in Florida. We provided here some links to the two bills, a link to the proposed regulation, and some other resources. So, Alan, I'm done, unless you got some questions.
No, Lester, that was excellent. If anybody has questions, you can email them to Lester or me. You've got our email addresses there. Beaver Brown and I are going to be updating our article, so we welcome any comments you might have on today's Thursday report. Send all of you an updated version of the article sometime next week. This is going to do a lot of good for a lot of Florida patients. It's going to do a lot of good for a lot of Florida physicians. So stay tuned. I had a lengthy call with a physician yesterday who has a PhD in cannabis studies, and she pointed out there's never been no one has ever died of an overdose of marijuana, whereas the oxycodons, people are dying of overdoses left and right all over the state and country. So just from that standpoint, getting the word out that this is going to be a legal and ethical way to handle pain for a lot of Floridians is going to be, I hope, a very good thing. Well, Lester, thank you very much. It was an excellent presentation as always. And for all attendees, please let us know what you'd like to see next. Keep those cards, letters, and calls coming, and may the rest of your day be billable.